All right. Mr. Holtz, identify yourself for the record, please.
Daniel Holtz.
Okay, calling case number 230-578-6001. People State of Michigan versus Daniel Holtz. Appearances, please.
Thanks, Judge. Good morning. Steve Benson for the people, 271-917.
Your Honor, may it please this honorable court, Larry Polk on behalf of Daniel Holt, who is present by way of Zoom, gives his permission consent to have this hearing by Zoom. Mr. Holt, state your name for the record.
Daniel Holtz.
All right,
Judge,
Mr. Polk, do you waive for? I'm sorry, go ahead, Mr. Polk.
Judge, we waive the formal reading of the warrant and complaint. My client stands mute.
Okay, formal reading having been waived. The court will not guilty plea. Argument as to bond.
Thank you, Judge. The people are going to be asking for remand in the alternative. If the court doesn't find remand is appropriate, we're going to be asking for a $10 million, 10% cash surety bond with GPS tether in home arrest. Your Honor, I'm sure I had the opportunity to patiently go over the allegations in this matter. Your Honor, in this particular case, we have the defendant who's on the screen, allegedly, Your Honor, at gunpoint, ordering the complainant victim in this matter into his vehicle. Subsequently, Judge, the defendant allegedly made the complainant perform oral sex multiple times on him, as well as vaginal and anal sex. Your Honor, the entire time wherein the defendant's firearm was purposely in view for the complainant to see that entire time. Your Honor, it's alleged that the complainant was in fear for her life the entire time. Subsequent to this incident, Judge, there was a sex assault exam that was performed. There was buccal swabs coming back positive, that there was very strong support that the defendant's DNA was found in the complainant. Your Honor, for matters of housekeeping, Judge, the defendant on your screen is presently going through another pending matter, Judge, and let me see what that's for. Oh, that's criminal sexual conduct first degree, 3 times over, Judge, as well as kidnapping, weapons, assault with a dangerous weapon, as well as
is that
felony
Mr. Vincent, is that a separate case you said?
That's a separate case, Judge.
Okay.
Yeah, that's an ongoing case, Your Honor, and that's why the people premise this by either asking for remand or attempting to justify the high cash bond.
Okay, do you know what the bond was in that case?
$500,000, and it still stands. $500,000 cash with GPS tether. Now, is that out of Wayne?
I'm sorry, is that out of Wayne County?
Yeah.
Okay, I'm sorry. Go ahead, Mr. Vincent.
Now, the ironic thing about the 2 cases, Judge, is there are many parallels. The defendant used his vehicle in both of those cases, brandishing the firearm, allegedly making the complainants perform sexual acts on him, Judge. Same, very parallel set of facts in this particular matter, Judge, with the gun. In that particular matter, it got to the point, Your Honor, where that individual allegedly had defecated in the back seat. In this particular matter, I think we potentially have urination. So, Your Honor, this defendant clearly is a danger, not only to these complainants, but to the community as a whole. These were people that he did not know. These were strangers. So therefore, the people do feel justified in asking for either that remand or that $10 million, 10% cash bond with the tethering house arrest. And Your Honor, just another set of housekeeping, that matter that is pending, that's ongoing with the criminal sexual conduct 3 times over. There's a final conference that's scheduled roughly about a month, a little bit less than a month. And I believe it's defense counsel who is also representing the defendant in that case.
All right, thank you, Mr. Vincent. Mr. Polk?
No, Judge, again, these are allegations, and I think it's just outrageous that we're going to have a jury trial, or it seems like an attempt to have a bench trial here at the arraignment. These are allegations set forth against our client, and he absolutely denies those allegations, not only in this case, in the other case as well. And that's what the whole process is about. Gives us an opportunity to flush out whether or not there was a prior relationship or knowledge of these individuals. Just because somebody says that absolutely does not mean that it's so. And so that's what the whole process is, to flush that out. And it's not to have these outrageous bonds that no one can even approach in terms of making. $10 million is a slap to the face of anything that's reasonable and just. And so I'm asking the court to shape a bond that is reasonable and that will allow him the opportunity, if he can make it, to post a significant bond and then move forward with defending himself against these allegations.
All right, thank you, Mr. Pope. Are you representing your client in the other matter that's pending that Mr.
I
Vincent
am, Judge.
referenced?
Yep, yes, I am.
All right, and is it accurate that he had a $500,000 cash bond with a GPS tether?
That is correct.
In your honor, because this is the second set of charges in a completely different circumstance, the people do feel justified, and the people would like to state the defense counsel's reputation precedes itself. He has defendant has very good defense counsel in this matter. However, allegedly, the defendant in this particular matter was doing the slapping and assaulting. And it's the people's job to slap back in this matter. So that's why we're
figuratively speaking. Figuratively speaking.
Figuratively, yes.
Okay. All right. One moment, Mr. Polk. Is your client working?
He was working before this incident, Judge. Yes.
Does he still have his job to the best of your knowledge?
I can't tell you that, Judge, only because I have not had any contact with his employer, but he was employed prior to this.
Yes, sir.
Okay. He says he does. At least that's what I'm hearing from him. Okay, court having heard argument, given that there's a pending case and seeing that there's a bond in that pending case, the court's going to impose the similar bond conditions as the other pending case. It'll be $500,000 cash surety with the following conditions. Mr. Holtz, you're not to possess, own, or purchase any handgun or firearm. You're not to have any contact with. And much like the other case, if you're able to post bond, GPS tether to work only. You have a probable cause conference July 26th. Right to preliminary examination August 1st. Mr. Polk, I assume this is unaffordable bond?
It is, Judge.
Okay. And so the bond redetermination hearing will be Friday, July 21st in front of Chief Judge McConaughey. Counsels and/or Mr. Holtz, do you have any questions regarding the bond conditions and/or court dates?
No, sir.
No, Judge.
Judge, if I may.
Yes.
This being the second matter that is now in adjudication, and the previous matter being a $500,000 cash, no surety with the GPS tether, the people would be asking for reconsideration in terms of this, the bond that Your Honor had just went over. At the very least, we would be asking for cash, no surety. However, we would be asking for more, just seeing as though that this is the second of the two matters that now is before the court.
Well, I understand your point, Mr. Vincent, but the counsel's representative is unaffordable. It doesn't look like he has able to post bond in the previous case. The court's satisfied that this is a fair and reasonable bond in this case.
Okay, thank you very much.
Okay.
Thank you, Judge.
All right, Mr. Cole, you have some tickets that you failed to appear on.
I've been trying to get it right.
Okay, just listen for now. State your name for the record again.
Calvin Cole, Your Honor.
All right. You have a lot of tickets that you failed to appear on. A capious and bench warrant was issued for your arrest for your failure to appear. The court's going to set aside the warrant and enter a not guilty plea on your behalf in these matters. The court's going to set a personal bond in these matters. Each of these misdemeanor tickets, they have a maximum penalty of up to 93 days in jail and or a $500 fine. You have a right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you can't afford one, one will be appointed on your behalf. The tickets are 17381-569. Alleges on September 17th, you drove in the city of Detroit while license not valid. On P875167, alleges that on August 1st, 2018, you failed to display a valid driver's license. You drove a vehicle without proper plates and driving an unregistered motor vehicle. P1322353 alleges that on May 25th, 2022, you drove while license suspended and drove a vehicle without valid insurance. In each of these matters, you have one court date, pretrial August 16th, in front of Judge Kenyatta Stanford Jones, which is August 16th, 2023, 9:00 a.m. You understand that?
Yes, Your Honor.
All right. Now to your more important matter. Calling case number 230-568-1301. People State of Michigan versus Calvin Donnell Cole Jr. Appearances, please.
Emily Reagan, P23-157 for the people.
Justice Shabbat, on behalf of Mr. Cole, who is formal reading, understands his constitutional rights and stands.
Formal reading having been waived, the court will enter a not guilty plea on the client's behalf. Argument as to bond.
Now, this incident occurred back on April 24, 2022, when police were dispatched to a location on Winston Street. They talked to the victim there. She said that the defendant shot into her home and then shot up her vehicle. Police did check. Police then checked the home and they found strike marks to the side of the residence, bullet holes inside the location, bullet fragments inside the location of the home. The officers checked the victim's vehicle and observed bullet strike marks on the vehicle and damage to the rear tail light and rear passenger window. They then canvassed the area and discovered 5 10mm spent shell casings. When the victim was interviewed on April 28th, she told the officers that she saw the defendant outside in front of her house. And he was upset because his ex-girlfriend, who allegedly he abused, came over to spend the night at the victim's home.
I'm sorry, repeat that.
Defendant's ex-girlfriend, girlfriend of the victim.
Okay.
Victim's home on Winston to spend the night after allegedly being abused by his friend.
Okay.
He saw the defendant sitting out in front of the house. He saw him drive down the street, turn around and come back about 2 houses away from her home. Then she saw the defendant shoot out the driver's side window of his car and enter her home. The victim states she knows the suspect personally and that he has also always been very abusive. Now, inside the home was her young children, plus the fiance of the victim, who was also in the home at the time. The victim identified Mr. Cole as the person who
Excuse me.
got into the house and shot at her vehicle. Now, back on 8/26/21, the defendant was charged with domestic violence. On 12/6/22, the case was dismissed because the complainant failed to appear. He also has previous convictions, Your Honor, back on.
Are they felony convictions?
Yes. Well, one is felony. Police officer. Nope, not a conviction. He was arrested for assaulting a police officer back on 9/23/2020. After almost 3 years, The case was subsequently dismissed after a competency hearing of the defendant. His bonds during that matter, I just want to mention this, Your Honor, went from $5,000 personal bond.
Were those matters that were dismissed?
That was dismissed.
Okay, I don't need to hear that.
Okay.
Okay.
And also, Your Honor, he is now on probation right now for a conviction for pistol purchasing without a permit. The case of carrying a concealed weapon was dismissed. He pled guilty or was sentenced on 2/23 of 2023, Your Honor. Failed to appear.
That's a pending case?
Yes, not probation now. In fact, he
Okay.
just charged with failing to appear on 5/30/23, and he was ordered to be remanded on 5/30/23.
So that's the probation violation?
Yes.
Okay.
The order was set aside and the warrant was recalled. Probation continued on 6/2/23.
All right, Mr. Ragnar, what is your bond recommendation?
I'm asking the court for $500,000 cash bond and GPS tether if he ever is able to post bond. You know, these previous convictions and so on are significant. Not as significant as shooting in someone's house a number of times when there's people there, there's kids there, and we've all known, read, heard about many cases over this past year even, where people are shot and people are killed by actions such as this. I think he is a very big danger to the community, Your Honor, a big danger to the 4 people that are charged with him assaulting without to great bodily harm, less than murder.
Okay, duly noted, Mr. Ragnar. Ms. Scheib?
Thank you.
I have many issues here with this whole thing. First off, Mr. Poole got charged with this May 10th, 2023, a year and a month later. Okay, it took a whole year and a month to sign this warrant on these serious allegations.
And that could be attributed to a lot of different reasons, but go ahead.
Correct. In that year, and since then, we are not aware of any incident whatsoever with my client and any of the complaining witnesses or their attorneys. Also, Your Honor, there is, and the people want to talk about what he was previously charged with.
But those are dismissed, and the court's not considering that.
Correct. Thank you.
Okay.
My client indicated he's not on probation. The people said he was on probation. If in fact he is on probation, it is a non-assaultive charge, they said. So he has no assaultive criminal history whatsoever. He's not an assaultive person. Now, my client was clueless about all of this when we went over the report. And the reason why he was clueless, Your Honor, because he had nothing to do with it. It's very concerning that my client got charged with 21 counts only because one person or 2-3 people said that he did this. He was never arrested at the scene. The police never saw him at the scene. The police never found weapons on him. Nothing. The police arrested him a year and a half after this incident. Nowhere in this report does it say anything about my client being witnessed by police officers or anybody there, or that they saw his car there, or they saw an individual run or hide or weapons or anything. The only thing that's in this report is someone makes a call and says, my house was shot up, and we know that the police saw that the house was shot up. But Your Honor, the address of this could be a very bad neighborhood. Anybody could have shot up this place. Anybody could have shot up the house. Anyone could have shot up the car. Luckily, nobody was injured. There was never contact made with any of the complaining witnesses. All of this is based on hearsay, what somebody said. Now, I understand the charges in front of you are very serious, and I know that you have to balance, community safety and danger. But given that this is a year and a half old, given that we are not aware of any incidents whatsoever with my client and the complaining witnesses, or that address, given that Mr. Cole has absolutely no assaultive history whatsoever, given that we don't have case history, flight risk, nowhere him being on the scene, nowhere anything the police officers are doing. All we have here is somebody makes a call to the police, says, my house got shot up, my car got shot up, and I am accusing Mr. Cole. And that's really all we have here in the report, Your Honor. So I am respectfully asking the court to consider a very high personal bond.
Is your client working?
He is not, Your Honor. I would respectfully, ask the court to consider a tether, usually on cases like this, to allow my client to get out on a personal bond and allow the court to feel, safe with their decision. However, given the age of it and given that there's really not one thing in the report other than what somebody said against Mr. Cole, I would respectfully ask the court to not consider that tether. But if the court is inclined to consider the tether, I would at least ask the court to consider allowing Mr. Cole to turn himself in within 24 hours with that tether. He isn't working, so he doesn't have to go anywhere if that's the only way the court is comfortable with this. But I would respectfully ask at least allow him to turn himself in. I usually ask for 48 hours, but I understand the charges in front of me, even though there's nothing here really against my client. So I would respectfully ask high personal bond, absolutely no contact, which there hasn't seemed to be an issue in a year and a half, and to allow him to turn himself in. And if the court is not having this for 48 hours or comfortable with that, then Mr. Cole will make sure to turn himself in within 24 hours.
All right.
Briefly,
Mr. Ragland, I've heard enough. The court's ready to rule. Ms. Shive, the court has heard your arguments with respect to that. These are serious allegations. There is at least one person, possibly two, that knew your client, and at least one was able to identify him at the scene. And based on the investigator's report, was very, very descriptive as to the details of why he was arguably there. So in light of that, notwithstanding your great argument, the court is going to impose a $200,000 cash surety bond in the amount of $200,000 with the following conditions. Mr. Cole is not to possess, purchase, or own any firearm or a dangerous weapon. He's not to have any contact with no contact means just that, not verbally, in handwriting, via email, social media, or through a third party. If your client is able to post bond, you'll be fitted with a GPS tether and under house arrest while this case is pending. The probable cause conference is July 26th in front of Judge Giles. Here's a strike that. Preliminary examination August 2nd in front of Judge Giles. Any questions as to bond conditions and or court dates? Oh, I'm sorry. Is this a affordable bond? Okay. His bond redetermination hearing will be July 21st, 9:00 a.m. in front of Judge McConaughey.
Thank you very much.
This is so crazy.
All right. Any other questions regarding bond conditions and or court dates? All right. Step aside, sir.